Hi again, everybody, and welcome to another episode of Ask the Lawyers. I'm Rob Rosenthal from AskTheLawyers.com. If you're lucky enough to have investments, you probably figure there's a risk that you could lose money. But what can you do if you think your investment has been mismanaged? Well, let's ask the lawyer. Here to answer our questions is attorney Frank Cristiano of Cristiano Law in Denver, where he practices broker malpractice law. Frank, thank you for joining us today. I appreciate it.
You're welcome. Happy to be here.
So investments have a level of risk, but we're talking about more than just, the natural ups and downs of investments here, correct?
Yeah, they have natural risk to them, and people who invest in securities should understand that there's a risk, and that typically the higher the risk, the greater the potential return. But I think that the reasonably well kept secret is that brokers have more responsibility to avoid getting their customers into unsuitable investments than the population understands. So it happens, I think, not infrequently that, and it depends on the market. If the market's strong, this stuff doesn't happen very often, although it does happen even when the market's strong. But particularly when the market goes down and people, particularly older people who are on fixed income and have an established retirement portfolio, can really, really get hurt in terms of losses. And typically they kind of look at themselves and they say, well, I guess that was my fault. Well, maybe partly it is, but, also, you're dealing with professional. If you're dealing with a broker, they have what they call suitability requirements. So they have to know their customer and understand what their investment goals are and what their risk tolerance is, and they have to recommend things that are in conformity with that risk tolerance and suitability profile that they have to establish with the customer. Those are brokers. Those are people that sell things. Investment advisors, it's even a higher standard. So an investment advisor, you go to an investment advisor, somebody who's not just a broker, but comes across as saying, I'm a registered investment advisor, and I'm going to help you establish your portfolio, and we're going to do well, and you're going to do well by me, and I'm going to charge you a certain amount of money to do that. They have even a higher standard. So if they are negligent in terms of creating a portfolio for me, which can mean many things, and you suffer loss as a result of that, then instead of just blaming on yourself, maybe you ought to come and see an attorney to see whether the attorney thinks that a claim could be asserted to recover some of your damages.
What sort of information, if I feel like, okay, my broker, my investment advisor may have mismanaged, may have been failed in their duties, what sort of information should I plan to bring to you when I come to tell you about it and get your opinion?
Well, the best thing is to bring in all the statements that they give you. Typically they're electronic statements these days. But the lawyer is going to definitely want to look at what the actual statements show, and not. You can describe what you think happened, but ultimately the lawyer is going to have to rely upon the written documents before he or she can make a determination as to whether or not there's an actionable claim for your losses. So bring in the statements or anything else from your file that you received from the broker. Particularly if there's a letter or letters or any sort of correspondence from the broker, bring that in as well.
Is there a difference?
We're pretty apt, I think, of kind of listening to the story and then obtaining the documents, and then based upon a review of the documents, determining whether or not there's a claim.
Is there a difference between mismanagement and outright fraud? Is that different? And what are?
There is. I didn't want to cut you off, but there's there's sort of a negligence standard, which is the mismanagement stuff, and fraud could be that they misrepresented things to the customer. So they represented the product to be something that it wasn't, and they're holding something back, and they're potentially motivated by their own profit motive in doing that. So they recommend something not because it's a good investment, but because there's a high commission rate on it, and it's easy to sell, and you can sell it in large quantities, and the broker can make a lot of money just with one sale and kind of move on to the next customer without having to spend a lot of time really giving the customer the kind of service that the customer is entitled to. So oftentimes there's fraud, but probably more times than not, there's things like suitability and violations where the investment was not suitable to the customer's risk tolerance and goals, or there's a there's a sort of a negligence standard with regard to a investment advisor, which he's not functioning in accordance with professional standards. And there's a lot of things to it. With risk tolerance is one, diversification is another, this, that, and the other. I think the bottom line is, I really do encourage people, particularly elderly people, if they suffer a catastrophic loss in their investment portfolio, might do them well just to go talk to an attorney who knows the field, which I do. So I'd be happy to talk to. But I think the numbers kind of have an effect. So if it's a catastrophic loss, particularly for somebody who's on fixed income and doesn't have the ability to recover from dramatic losses, it's probably not a bad idea for them to see a lawyer. And then there are remedies, even though I think the public typically thinks there's not.
I hear about churning. Can you tell me what churning is and how that fits into this conversation?
Churning is another thing that mostly brokers involve themselves in if they were going to be bad brokers, and that has to do with the turnover in your account. You don't see that nearly as much anymore with mutual funds and this, that, and the other. But it used to be they'd sell you a ton of stocks, and then you'd sell them, and then they'd rebuy them, and this, that, and the other. And your portfolio could turn over 4 or 5 times a year. And what that did would be to really maximize the commission that the broker was making on your account to your expense. So the broker's really being motivated not so much by his or her concern for your investment welfare, but to generate a lot of sales so that he can generate a lot of commissions. So churning is one of the aspects as well.
So it seems like that would be a warning sign that maybe you could go, something doesn't seem right here. Are there some other warning signs before you get to that point of catastrophic loss? Are there some other things you could look out for that you go, something doesn't seem right? Then maybe my account's being mismanaged?
Well, typically the broker always has to have a document in his file that the customer fills out that goes over risk tolerance. And there's various categories that they fill out. One could be speculative, another one could be aggressive growth, another could be moderate growth, another could be conservative, another could be income. And they go down, incrementally in terms of the amount of risk that is suitable for the customer. So the more conservative you put on the document that you submit to the broker, the more conservative he's going to have to be in terms of him abiding by standards. So one of the things you can look for is, what did I really put, in my customer sheet that the broker or the investment advisor should be aware of in terms of my risk tolerance. And if that's really out of whack, then you've got a lot stronger case than if you put, I want to speculate. You put, I want to speculate, there's not much you can do. I mean, they've speculated.
Right. Is there an expectation that the broker will update that sheet? Because it seems like,
they have
if somebody doesn't in their
requirement periodically update that sheet. So it isn't just something that sticks with you for the next 20 years. It's something that they have to periodically review with you and make sure that what you're doing is consistent with what your investment goals are and risk tolerances at that point, which may change. You might get, most of the time people get more conservative as they get closer and closer to retirement age. And when they get to retirement age, they get a lot more conservative. So somebody who's in retirement mode, they got to make sure that there's not much defense to some broker saying this guy wanted to speculate, even though he's in a retirement mode. And the other thing is, percentages are significant in terms of, did the broker just get you in the, to the extent of 10% of the value of your portfolio in something that was aggressive, or is it 100%? or is it 80% or is it 60%? The greater the percentage, the greater the risk. And then there's things about diversification as well that have to be taken into account.
It sounds very complicated. At what point, Frank, do you contact an attorney like yourself? Do you have to wait until, oops, there's a catastrophic loss and all my money's gone? Can you get an opinion somewhere along the way and go, hey, can you look at this? At what point do I contact an attorney?
Well, typically it's a catastrophic loss, where somebody suffers and it has to be. I mean, the numbers have to be fairly significant. I don't think a lot of lawyers are going to take cases that are less than six-figure cases, unless it's really obvious. Sometimes it's obvious, and sometimes we'll take higher five-figure cases. But if it's a six-figure or higher loss, then that's and you've got a certain amount. You've got at least 2 years to bring the claim. Maybe 3 probably is even a better argument. I'm not going to give any statute of limitations opinions on the internet, but you've got some time. Maybe 1 year is the absolute minimum time that you've got to go make a claim. And it's not very hard to make these claims because they all involve arbitration as well. So,
is there hope of getting back all the losses? Is it generally a percentage of the losses, or is it all over the place?
Well, it's always better. I mean, the first rule anybody wants to follow, no matter what it is don't have a need to go to a lawyer, and then you won't have, and then you won't have these losses. But if you have these losses, you have to pay an attorney a percentage of the recovery to recover it. And typically, the brokers are going to offer some sort of a compromise. So it's unless you really hit a home run after an arbitration hearing, it's not going to be 100%. Even then, you're going to have to pay your attorney. So it's salvage time. I mean, it's not, if you get back 50% of your losses, you're doing pretty well. But 50% is a lot better than nothing. And I really do encourage people who have lost a lot of money, when they shouldn't have, when they shouldn't have been the aggressive, the investors that their brokers made them into, caused them to lose a lot of money. They should see an attorney, and then have the attorney just, answer their questions. Most attorneys are going to answer the phone if they call about investment losses such as this, and they're going to give them their professional opinion as to whether or not it's worth pursuing. And there is, like I said, since it's arbitration, there's a lower threshold too.
All right. Frank, thank you so much for your time today. I appreciate you answering our questions. My guest has been Frank Cristiano of the Cristiano Law in Denver, and that's going to do it for this episode of Ask the Lawyers. Please take a second, click on the button at the bottom of the screen, and subscribe to our YouTube channel so you don't miss any future episodes. And if you need more information about broker malpractice, or if you're ready to choose a lawyer that lawyers choose, visit askthelawyer.com.